It's a real great honor and pleasure to speak to you, to have this opportunity to share with you the experiences and observations on reforming legal aid in Eastern Europe. It's a particular honor in many respects, being here in a country which really spearheaded efforts that resulted in adoption of the UN principles and guidelines on legal aid. It really played an essential and critical role in what we currently have. It's of course the country which has probably the best legal aid system in the world. It's a place where I professionally learned many things which really defined what I would be doing for quite a number of years till now. And that's, for me personally, and it's great to speak after my mentor, David McQueen-Mason, who is the mentor for many of us, I'm sure, as well, in this room. It started in 1997. I would even say that, yes, thank you, so if you could help me, that actually it probably could be, in a way, without making these very loud words, the starting point of legal aid reforms in Eastern Europe. Because in 1997, human rights advocates from Eastern Europe, about 30 people, came to South Africa, hosted by David McQueen-Mason, to really expose us to the transition efforts to democracy. Something that we very much needed to learn from other experiences, because we were coming from countries which had recently ended communist regimes and had no experiences of how to work with human rights, how to engage in advocacy efforts, because none of that was possible or available in our countries until very recently. We were inspired by almost everything we saw, many inspirations that really continue to really support our work in Eastern Europe and globally as we continue our work in many areas. One of the areas was legal aid. We were absolutely fascinated what we saw. We understood that there is nothing remotely similar in our countries, while at the same time we have an European Convention which says that legal aid is a fundamental right. It has to be provided to everyone who is indigent and in the interest of justice. The European Court has even said that real aid should be real and effective, not theoretical and illusory, and defined many elements of effective legal aid systems. None of that was really given any actual practice. So we started, several civil society organizations decided that we had to do something about that, as nobody had done anything before. We started to look into data to understand how many people are asking for legal aid, who is providing legal aid, how is it done. We could find nothing. So there was no data, no information. Nobody knew anything, except that actually everyone probably would agree if you would talk to them informally that actually the systems just generally malfunction. And of course you have defendants, the accused people who have no voices to defend their rights. So there was no one who was advocating for their behalf. So the very first thing we did was to really do the very essential initial kind of a basic study to map the state of legal aid in 10 East European countries. And then findings, if you could, they were not surprising, and very basically actually nothing was functioning, very few people were getting legal aid, there were no guarantees, for access to a lawyer in preliminary stage, complete absence of civil legal aid, no ability for people just to even receive basic information, advice for free on anything, and very inadequate budgets. But at the same time, as we presented these reports to governments, they didn't seem to care much. The findings we produced didn't seem to make much impression. It became obvious that we had to do some more digging, kind of provide more of like a empirically, the more convincing evidence on a real state. So we shifted to more rigorous research methods, and then in 2002, just I have you in the next slide, just a few figures. For example, in Bulgaria, the kind of a representative sample of case files combined with interviews with 2,000 inmates, really established the very first basic figures of what was really happening, just demonstrating that, that 35% of people who were eventually sentenced to prisons, never had lawyer at any stages. Like their own 86% of them did not have a lawyer during the preliminary investigation stage. The people who, those in cases which formally had assigned lawyers, the surveys of inmates, we established that these people had never seen them, so there was no knowledge of even that they were represented, apparently, according to formal files. Very similar situation in Turkey, maybe some figures even kind of look worse than Bulgaria at the time. And then in the next slide, I also have figures just providing on Ukraine, where, for example, the 62% of suspects said that they were asked bribes in exchange of the release or discontinuation of the proceedings. The 72% of them said that they were never informed about their rights, and 64% refused legal aid because in the majority of the cases they were told by policemen it would be better for them to do so. So the information of this kind was really an important starting point to engage with governments to really describe systemic nature of the problems. And the next slide, please. So the systemic nature that we found, the first one was there was no legal aid policy of any kind. None of these countries had legal aid laws. So if there are no laws, the legal aid provisions are spread across, criminal procedure codes, some other guidelines, but it was nobody's responsibility. Ministry of Justice was not responsible for legal aid. The court was not responsible for legal aid. The Bar Association was responsible to assign a counsel, but they were not responsible for quality or ensuring the access, because almost no pay or very little pay that was provided. So it was nobody's kind of the responsibility. As a result, nothing functioned. In some countries, some significant amounts were spent on legal aid, but no governments didn't know how much money they were spending on legal aid because, again, nobody was in charge. We found that legal aid lawyers' appointment procedures often were really the corrupt. Not only that police and investigation authorities would appoint lawyers, but this led to the concept of pocket lawyers. So the lawyer who is dependent on investigator to get a good case in exchange of doing like a formal function of certifying, the meeting of procedural requirements in mandatory legal aid cases. And overall, of course, there was no culture of legal defense in the best interest of the client because there were no criminal defense bars. There are not many criminal defense bars, unfortunately, now in many countries, but these were some of the very serious systemic problems. So how did we start? So like the first country really where some kind of innovations were experimented, was Lithuania in 2000, where government was spending money on legal aid, but they were concerned that they knew nothing about how the money was spent. And I remember David Mason telling me that how they kind of piloted salaried lawyer model to really demonstrate the cost efficiency so that it would cost less, but if the quality would be more, there would be ways to improve the quality through quality assurance mechanisms and really try to build some rudimentary basis for the criminal defense bar. So the Ministry of Justice of Lithuania got convinced. They said, we would like to try it. They came to South Africa to learn firsthand as well their experiences and how the process was started. As part of that, a working group was also established in Lithuania by the Ministry of Justice to elaborate kind of a new legal aid legislation. So in the following slides, I actually have, if you could go forward just quicker now, so like some of the really critical issues that the working group was dealing with, how to kind of the main question being how to deliver publicly funded services in the most efficient and accountable manner. That's the main question for the public body to do. So that kind of in the working group kind of we dealt with scope, eligibility, stages of criminal proceedings, questions like who is delivering, what should be the role of the bar, how to fund legal aid, so on and so forth. All of that resulting in adoption of a new legal aid law in Lithuania, which established the management structure, National Legal Aid Coordination Council, and created a mixed model of legal services delivery. Now, afterwards, this was followed by other countries, like in Bulgaria, Georgia, Moldova, Ukraine, all in the subsequent years, but went through the similar processes. The piloting, benchmarking the costs of the quality through the public defender offices, understanding the dysfunctionalities of the system, and then developing, actually convincing the government, undertaking the research, creating working groups, and then adopting legislation. Now, for example, Georgia, Moldova have independent legal aid boards, very similar to South Africa. The Georgia has full-fledged public defender systems. Other countries have mixed models of legal aid delivery. Now, I will skip the next few slides. This presentation, which is PowerPoint heavy on text, will be provided on a USB. But I will just take the slides on lessons learned. And that, and the lessons learned, for me, just to take another, like the last 1 or 2 minutes, would be that the adoption of the legal aid laws, which took 3 to 5 years, is just the beginning of a very long process of legal aid reforms. And for that reason, because there is no perfect model, and it's very hard to often agree on perfect model at the very beginning, I really believe, and then I think that evidence of some of these countries, at least in Eastern Europe, kind of support that as long as it really became somebody's responsibility, there was an institution to become in charge, then its institutions start to work, and the people there want to succeed. Institutions need to survive. So if you create legal aid council, even without much functions at the beginning, with some flexibility to experiment, then they move things forward because they become advocates, not civil society or others, for the reform to succeed. In Georgia, in 2007, law was not perfect because because government was not that open to independent legal aid board. Just last year, they amended the law to create full independent board to be accountable to the parliament only. Again, something that they learn in practice, and then this is the process moving forward. The working groups for drafting laws, very important thing to build political consensus and get support for the legislation. The gradual approach, you need to start somewhere. You cannot cover all legal aid. So we started with criminal and primary legal advice information for all. And then to consider joining, really bringing on criminal legal aid, or civil legal aid, sorry, at a later stage. I think, for us, piloting and testing models for legal aid delivery, it has been very important, like at the public defender or other models, because, the culture of defense is something that will take much more time to be accomplished, and something that legal profession you need to spearhead and take leadership of. And then without proper institutions in place and incentives for lawyers to specialize and then, be accountable for their work, there is no way for this to develop. And the final point, and interconnectedness of the rights, because the legal aid does not function in vacuum, and I think UN principles and guidelines are very useful documenting that. It also talks of access to information, right to silence, and other things, which are not directly speaking legal aid. But for legal aid to be effective, there are many other things that need to happen for legal aid to be effective. So person should know about his or her rights. Person should be able to fully enjoy their right to remain silent, being able to make their contact, and so on and so forth. So like thinking about what other important elements of effective criminal defense really need to be provided for legal aid to be really effective. Thank you very much.